Good morning. This is Daybreak on Citizen Television. Thank you for staying with us. The hashtag on Twitter is Daybreak. The SMS code is 22422 at Citizen TV Kenya, at Ayub Abdikadir, and at Safin_Acheng. Before we get into the discussion this morning here on the broadcast, we are keeping an eye on the situation in the country and will update you, give you an assessment of the situation as the 3-day of protest called by the opposition kickstarts today on Wednesday to tomorrow on Thursday and on Friday. Yesterday, the leadership of the coalition political party said that the protests are on amid the failure of a truce bid by stakeholders who called for dialogue between the top leadership in the country, calling upon the president and the opposition leader Raila Odinga to bridge their differences. On a working day today, the head of state, President William Ruto, will be commissioning a water project in Kericho County. This as the Interior CS, Professor Kithure Kindiki, assured Kenyans that they will be protected by the government and calling upon Kenyans to go about their businesses. And the government saying that all primary and secondary schools in Nairobi and Mombasa were ordered to shut because of the uncertainties over the protest. We'll be keeping an eye on how this situation develops and, of course, give you the live updates here on the broadcast. For now, though, we discuss the rulings by the Supreme Court and the Court of Appeal in effect to life sentence and the death penalty here in the country. And with me in studio is Wesley Waku, who is a legal officer with the Justice Department. On my immediate right, at the center, Justice Defenders, not department. At the center is Steve Ogola, who is an advocate of the High Court. Good morning, gentlemen. And also Demas Kiprono, who is a campaign manager at Amnesty International, to give us the account of what these rulings by the Appellate Court and the Apex Court mean for the country. And coming to you first, Steve, to understand on perhaps the ruling by the Supreme Court in December of 2017, which declared the mandatory nature of the death penalty unconstitutional. The Appellate Court ruled also that life sentence is unconstitutional. I mean, going forward then, what does this mean for the criminal justice system and further cases that will come before the courts of law in the country?
Thank you, Ayub. The Supreme Court judgment that you are referring to, that is in the celebrated case of Murwatetu, the court held that the mandatory nature of the death sentence was unconstitutional, but it could be used as a maximum sentence. The reasoning was that sentencing is a judicial function, and when Parliament is legislating in a manner that confers, that in a manner that is definitive, in the sense that it says that a person convicted of an offense of murder, for instance, would be liable to a mandatory death sentence, that would be unconstitutional because that the function of sentencing is primarily a judicial function. But it fell short of declaring the death sentence itself as unconstitutional. So yes, it remains constitutional, but it's at the discretion of the judicial officer to make it out. That was celebrated because Kenya has been an abolitionist state by practice. We have not really abolished death penalty in our laws, but by practice we have not, I think, committed someone to we've not hung someone in a very long time, I think since 1987, yeah? But that celebration appears to have been short-lived because a few years later, the Supreme Court seemed to have backpedaled on that judgment through what they considered as a clarification. And the clarification brought more confusion than clarity, because then they said, no, the Murwatetu judgment only applies to murder cases. Because, you know, there are other offenses like treason, espionage, and robbery with violence that also attract the death sentence. But they said, no, you have to incubate the questions relating to the death, the mandatory nature of death sentences in other cases. You have to incubate it from the High Court to the Court of Appeal to the Supreme Court. So that confusion was, that clarity was unwelcome because the courts were already implementing the Murwatetu as a guideline judgment to administer the death sentence as a maximum sentence in other related cases. But we've also seen it's interesting, we've seen the Court of Appeal ruling now, judgment, that equally declares the mandatory nature of a life sentence also as unconstitutional. So then the reason it doesn't make sense to condemn someone to a mandatory life sentence when the death sentence itself has been declared unconstitutional. That looks like an unfair treatment to a same set of offenders. So in short, yes, Kenya is making progress because we are on our way to decriminalizing or we are on our way to decriminalizing the death penalty. We are going to make it, at some point, we are going to reach a level where the death penalty itself is deemed to be unconstitutional. So the first step is we've made it the mandatory nature, we've removed the mandatory nature, so it's an optional sentence to be meted on case by case. I think at some point, we will reach a point where even the death sentence itself might be declared unconstitutional.
Okay, and coming to you, Demas, I'm looking at the last, in 1987, and many who have been sentenced to death, but no one has been hanged to death, except for the last case which happened in 1987 of those who have been accused of orchestrating a military coup which was foiled. And this coming from the apex court and the appellate court which pronounced itself on the life sentence issue. I mean, then how do we then bridge this? Because if there has been no person who has been hanged since 1987, yet many have been sentenced to death and are in prisons across the country. I mean, what is the practical aspect of how this will be embarked upon?
Thank you for that question. I think, first of all, as Amnesty International, we take a very ideological view on the issues of the death penalty and to some extent the life sentence. And we say that every person, no matter what they've done, have the inherent human dignity. And so as governments, are we then to say that we are supposed to punish people in a manner that we see that is cruel and unusual? So our first limb on opposing the death sentence is that it is a form of torture. It is cruel and unusual treatment. And even if you go back to our constitution, it says that no one should be subjected to torture under Article 29, and also Article 25 lists torture as one of those things that can never be done to you, no matter what you've done. Even if you're caught committing a criminal offense or you're caught making other people suffer, you're not supposed to be tortured, because we are saying that the government should be better. Be that as it may, we have been in practice or de facto an abolitionist state, as my colleague has mentioned here. So we have this in our laws, but we have not been using them. And so why should we continue having these sentences? And it goes back to, why does the criminal justice system take a person into incarceration? Is it to punish? Is it to rehabilitate? Is it to make it good for the victim? And so it is a combination of all these things. And in Kenya, we have been viewing prison sentences as punishment. But what actually we should be viewing it as a rehabilitative tool to, for instance, maybe reintegrate these people into society later. I understand that there are certain crimes that are deemed as very bad. For example, crimes against children. Even in this case, by the way, the person was the petitioner was accused of defiling a 4-year-old, which is reprehensible. But the court found that the prospect of a person, first of all, spending their entire life without any prospect of being released may be considered cruel and unusual. But then it also said that such people are denied the mandatory nature of that Section 8 of the Sexual Offences Act kind of removes that mitigating factor whereby you can approach the court and say, yes, I might have done this, but these were the prevailing circumstances. I have children at home, so on and so forth. So it removes that possibility and just makes the court look at you in terms of guilt and innocence, and does not look at you beyond that. And so this is a very progressive judgment in that it gives the judiciary proper discretion to look into the circumstances of a person, but also it also challenges our country, our criminal justice system, to be more hell-bent on rehabilitation, apart from punishment. Yes, you may be punished, but you need to be rehabilitated. And so that we'd have a more whole society. We've always argued that people get more hardened when they go in because of the prison situation there, the overcrowding, the mistreatment, and so perhaps this encourages us to make our criminal justice system more amenable.
We'll talk about the crowding aspect, the money we spend on those who are serving life sentences, because the government spends about 87 million Kenya shillings in a year for the upkeep of those who have been sentenced to death, and also the reason for jailing a person, which is to deter, to rehabilitate him to be a better person when he reintegrates back into the society. But Wesley, coming to you, then by virtue of this, the two pronouncements by the top courts in the country, that is the Supreme Court and the Court of Appeal, does it then mean that prisoners who have been sentenced to death under the old law, there are chances of resentencing going forward?
Thank you for your question. I believe that from the Supreme Court Murate 1 created a new avenue. It created a new way of retrogressive application of that judgment, so that those who are already on death row or those who had been convicted of the death sentence can be able now to again approach the court to be given definite sentences. Because as my colleagues have intimated, that you find the aspect of being on death row creates a sense of cruel and inhumane treatment. It takes away a person's right to mitigate the circumstances that may have caused them to commit a certain offense. And many of them range from the aspect that you are a first-time offender, that you pleaded guilty to the particular offense, saving the court valuable time as far as going through the vigorous trial process. So by the pronunciation of the Murate 1, the court created a new avenue for the accused persons to go back to court to now mitigate, so that we can now have that aspect of the court exerting its discretionary principles in sentencing those particular individuals.
Okay, Steve, I mean, there is the question on the conviction for murder, for example, robbery with violence, attempted robbery, and cases that, for example, Demas has mentioned of defilement. Then do the two rulings, therefore, give the judges who will preside over such cases I've mentioned the discretion to, for example, look into the Murate matter that the Supreme Court had cited, and based on the evidence and the threshold presented before them, embark on the life sentence issue? Is it on case-by-case scenario and the threshold of the evidence presented before them?
I think you have raised two issues on the applicability of Murate judgment to other similar cases, and the graduation of those cases. The first issue started well, because when the Supreme Court said that the death sentence, insofar as it's mandatory, is unconstitutional, and made it maximum and not mandatory sentence, the lower courts, the superior courts below, that is the Court of Appeal and this the High Court, and then the other courts, the Magistrates Court that tried robbery with violence, for instance, started applying that principle in Murate in these other cases. And for some time, it was going on well, because then, if you had been charged with robbery with violence, which then attracted the death penalty, then the magistrate, the trial court, had the discretion to either sentence you to death, because that is now the maximum sentence, or to sentence you to life sentence or such other sentence that the court deemed fit based on the circumstances of that particular, the facts of that particular case. And Murate itself provided a scale that allowed courts to look at the heinous nature of that offense, for instance, whether this offender is a first-time offender, and so on and so forth. But halfway through, the Supreme Court came back with what they called a clarification and said, no, do not apply Murate to cases other than those persons who have been charged with murder. So you can't apply the principle in Murate in robbery with violence. You cannot apply the principle in Muratetu in treason and espionage. These are cases that attract the death penalty. So they said, no. The reason why we don't want to apply this principle in Muratetu is because we want questions relating to the applicability of the death penalty in robbery with violence to be incubated from below. I think administratively it looks exciting because it makes the Supreme Court busy. But in terms of logical thinking, it's a totally irrational position, because once you've found that the mandatory nature of the death sentence is unconstitutional, you cannot then limit its application. So confusion arose from there. But also, the application generally, even within this, the rubric of people who have been charged with murder, the court said two things. One, at the time when this Muratetu judgment was delivered, if you had been convicted of murder, only murder, and you're already serving a sentence, you had a second bite at the cherry, you could then apply for resentencing. So that is what the retrospectivity of that sentence. If you were convicted after Muratetu, you are deemed to have benefited from that guideline judgment anyway, that the court ought to have taken into consideration. For those who had been convicted and had appealed, if you had been convicted before the Muratetu judgment and had appealed to the, because murder is tried only at the High Court, at the court of first instance. Those who had pending appeals at the Court of Appeal needed to think whether they want to discontinue the appeal, so they go back and apply for resentencing. Because if you apply for resentencing, it means you agree with the court on the finding that the court applied the law correctly, and that you're only aggrieved that the sentencing is punitive. For those who are appealing, it means you are aggrieved by the finding of the court, the finding of guilt. So then they had the option of withdrawing the appeal and then benefiting from resentencing, or not withdrawing the appeal and then losing out on resentencing. So the discretion. The discretion in the application of Muratetu, I think for our viewers, Muratetu is the case, the lead case, what we can call like the main case that triggered the finding that death penalty is unconstitutional. The discretion now lies in a very limited context, in the sense that Muratetu now applies only to murder cases. And number two, when a judge is applying, because now magistrates don't try murder cases. Only judges try murder cases, the High Court and then Court of Appeal on first appeal, and then the Supreme Court, maybe on a second appeal, if there are exceptional circumstances. Now, when a judge is applying Muratetu, the discretion whether to sentence you to death or life imprisonment or such other term that the court may determine is based on a graduated scale that is embedded in the Muratetu judgment. Are you a first-time offender? How old are you? What was the heinous nature of that offense? And so on and so forth. So that in the court's discretion, one person may be committed to life sentence, having been found guilty of murder. Another person may be committed to death, having been found of murder. Another person to 30 years imprisonment, based on the circumstances of each case. That is the kind of discretion that is now being used. We celebrate that. We celebrate that. Now, very soon, the Supreme Court will have an opportunity to apply its mind to the life sentence, the mandatory nature. I'm sure that matter will find its way, if it already has not, to the Supreme Court. And I can tell you as a practitioner, using the principle that sentencing is a judicial function. So that is, for me, that is the primary argument. The other secondary but equally important arguments are like, less cost. How much does it take to keep people in prison for life? It could put a strain on the economy. Those are important arguments, but the core argument is that if mandatory sentences are unconstitutional because they interfere with the judicial function, then you can see clearly where life sentence is imposed by law, you can see a reversal of that.
I'll want to point out the example, of course, in the course of this broadcast of the Willie Kimani murder case and his client and the taxi driver who were brutally murdered, and the ruling by Justice Lesit, which had taken over 6 years, and the different sentencing in terms of the levels of the officials who are involved. But coming to you, Demas, and I'm looking at the ruling by the judgment by this the appellate court, which declared life imprisonment also unconstitutional. I mean, doesn't this alter the matrix because on how the courts generally will dispense on matters such as capital offenders or cases that are capital in nature?
Yes, it does, and I think this is a development that is coming out of the thinking of the Muratetu case, and it is a drive towards a more humane society, but also a society where the judge looks at every suspect or every accused uniquely. The criminal justice system has suffered a long time over issues of mandatory sentences, and we can even get precedents or examples from other countries where, for example, when a society decided that drug offenses were too bad and imposed mandatory sentences, you found that whole communities were devastated because, first of all, people who were often caught with drugs had a problem and were actually sick people who needed rehabilitation, who needed to be taken to rehab, right? And so the mandatory nature of sentences generally in criminal justice has been found to be not working. The other thing is that even the whole concept of deterrence, the whole concept that if you make a certain crime very, if the penalty to be very steep, that people will not do it, is not true. We have seen, for example, in the USA, that countries that still maintain the death penalty, for example, not countries but states, tend to be less safer than the countries that don't have it. They tend to have more prevalence of criminal conduct that actually warrant these very stiff penalties. And so perhaps we need to rethink the issues of mandatory sentences, the ideology of punitive punishment rather than trying to make a person better, and also a holistic view of criminal justice, where we realize that actually sometimes even the people who end up being sentenced were actually subjected to certain societal prevailing conditions that would have made them more likely to conduct certain crimes. And so as a society, I think our judiciary is going to the right direction, that they are taking their constitutional mandate seriously in terms of they are the ones to determine whether a person should get the maximum, the minimum, or whether the conditions that they found themselves in warranted some mercy from the courts. And I recall a case where a woman had killed her husband, and when the court looked through the case, found that this lady had been subjected to something akin to torture. The husband used to beat her severally. She reports, nothing happens. And that was actually some grounds for the court to decide the case a certain way. And so, yes, we need the courts to have the tools. I suspect that this will be subject to more litigation. I suspect that there will be people filing reviews so that their sentences may or may not be reduced, and I think this is a good thing.
And given that you have mentioned the example of that case and the matter before a court of law, and clearly there is the understanding that even the judges and although the magistrates who handle these cases immerse themselves or dip themselves in the real reality, trying to understand the context of what has happened before they determine and rule over a matter. Wesley, I come to you. Does this again bring about, on one end, the sanctity of the human life, because the Constitution of Kenya regards the human life as a sanctity. And then on the other end, how do we then bridge between what the judgments by the apex court and the appellate court, and a society that is now caught up between retributive and restorative justice?
Thank you for your question. I think as a judicial officer, a court has to balance the interests of various parties. Other than the victim, the court also has to look at the aspects of the accused person. You realize that when the court is put at that situation where they have to give out the mandatory capital sentence, you find that the court has no leeway on looking at those other vitiating circumstances. And you find that the new jurisprudence that is coming out from our courts now has created a new leaf on how we look at our restorative justice. We are moving away from the punitive nature of our criminal system. And by that, we are even going further to having our prisons not being seen as prisons, as rather as correctional facilities. And this creates a new angle of us looking at how we confine those who have offended the laws of this country. And more importantly, you find that many of these persons who have served these long sentences or have been put on death row tend to be given a second chance back into society because they conduct a lot of rehabilitative programs while they're held in the various correctional facilities. And I think by the court now creating a new angle for them now coming back for resentencing, the court can now be able to look at those circumstances that they have actually reformed, because you find that an individual has been in prison for close to 20-25 years, and you ask yourself as to whether keeping them longer there creates any positive impact as far as society is concerned, because you realize that even though they have committed an offense, there has to be that opportunity for them going back to society, becoming a productive member of society, regardless of the fact that they have committed the various offense they have. And if we continue with this nature of giving out maximum sentences, such as life sentence and death sentences, we forget that the basic essence of justice is to provide an angle for restorative justice. And when we forget that this other aspect of rehabilitation and restorative justice, we find ourselves in a situation where we are an eye for an eye, which now results to all of us being blind. It does not create a situation whereby now it deters the society from committing these offenses. And I like the way that the judiciary is taking a new angle towards looking at the question of sentencing and our penal laws. You find that we are now focusing on the end result. After someone has committed an offense, do we just condemn them to the various correctional institutes, or do we now look at them leaving those correctional institutions? Because even the judiciary sentencing policy guidelines, one of the key mandates of sentencing is rehabilitation. So after you have been sentenced to life imprisonment or you have been sentenced to death, and as you've noted earlier that we have not done any death since 1987, what is the end result of you being there? Are you likely to use the rehabilitative programs you have acquired while incarcerated and contribute back to society? I think it's a very important conversation that we are having as a country, and we are moving forward towards the way of embracing, rather than punishing, we are now embracing the restorative justice.
Thank you. And when we get back from the break, Steve and Demas, we'll take a look at a research by Oxford University in the United Kingdom and also the Kenya National Commission on Human Rights as to the percentage of people in prisons who are serving death sentence. And largely they are made up by people who are experiencing mental health problems, who have low cadre education, poorly educated, from low-level precarious jobs, and with little financial security. We'll take a look at the societal aspect and how the justice system looks into this, and the samples done by the Death Penalty Project, DPP, in partnership with the Kenya National Commission on Human Rights and the University of Oxford in the UK, as well as keeping an eye on the day the opposition has billed as anti-government protest day, set to extend until Friday this week. And yesterday, calls for truce have failed despite key stakeholders raising concerns about the country's political stability. The hashtag on Twitter is Daybreak. The SMS code is 22422. At Citizen TV Kenya, at Ayub Abdikadir, and at Safin Achieng. When we get back from the break, the discussion continues here on the broadcast. Stay tuned.